Alrighty, party people of the interwebs, it is your daily dose of the Fannie. We have a meaningful update in the Fannie Willis RICO extravaganza of a debacle of an injustice. You will recall last week, Sato, attorney for Donald Trump, had presented a motion to dismiss the indictment on the basis that it was violative of First Amendment rights. That is to say that the entire indictment basically criminalizes free speech, that it is based on facts and allegations that are only related to free speech, and that the RICO indictment basically seeks to criminalize what is First Amendment protected political speech, the most important type of free speech that there is out there. Maddow presented a motion to dismiss that basically covered two aspects of an argument. One is that the law was facially invalid, that is to say, invalid on its face. That was the weaker of the two arguments. The other argument was that it was unconstitutional, First Amendment violation as applied to the circumstances. We watched that hearing live together, and I was watching it, and I was commentating as we were watching. The more that they argue that this needs to be dismissed and the more complicated their arguments are, the less likely it is that Judge Scott McAfee is actually going to dismiss this case, because the more you argue nuance in terms of the as-applied First Amendment violation protected speech, the more you have to argue nuance, the more the judge is simply going to say this is going to be in your defense at trial, and it's not at the stage of a motion to dismiss that I'm going to determine in this nuanced argument that as it's being applied to the speech in question, it is violative of the First Amendment and therefore should be dismissed. Now, there was the other aspect of the facial unconstitutionality, the facial First Amendment violation of the statutes at issue. And I thought that was a failing argument right off the bat, because they had basically conceded that this had already been interpreted under Georgia law, and they determined that it was not facially invalid. Therefore, the only saving element could be as applied unconstitutional, and the judge rendered his decision. Today, I had made my firm prediction that Scott McAfee, not through corruption or anything, just based on what we saw, it was exceedingly implausible that he was going to grant this motion, and I predicted he was not going to grant this motion, and lo and behold, today, he rendered his judgment, a 14-page judgment that you could have drafted from the commentary last week. He dismissed their motion to dismiss the indictment, basically coming to the conclusion that the law is not facially invalid, and as applied, we cannot come to that determination right now because the state has alleged that the speech in question is potentially criminal in nature, because in the indictment, it's alleged that the speech, which is speech at the end of the day, was nonetheless speech in furtherance of a crime, which is itself not protected by the First Amendment. So I'll just read a few of the highlights from the decision, and I'll try to find my clip where I predicted that this was going to happen. And I'm batting 1 for 2, which is not bad, but I'm still hopeful that I'm going to ultimately be 2 for 2, because I predicted Fannie Willis was going to get disqualified from this case. Judge Scott McAfee did not have the judicial cojones to do that, but he laid out a fact pattern for the Georgia Court of Appeal to do what he ought to have done, and that is currently under appeal now. So I still am holding my breath, crossing my fingers that I will be batting 2 for 2, because if the Georgia Court of Appeal comes in and disqualifies the Fannie, I am going to say that I predicted it right. But for the time being, 1 for 2, and the Judge Scott McAfee did not grant the motion as drafted. So in the beginning, the judge basically summarizes what's going on. Order on defendant's motion to dismiss under the First Amendment. The defendants seek to dismiss the indictment on as-applied and facial First Amendment grounds. U.S. Constitution, amend, yada, yada, yada. They argue this prosecution violates the First Amendment's protections of political speech and activity, freedom of association, and the right to petition Congress as applied to their alleged conduct, and further contend that the indicted charges are overbroad. After considering the extensive briefing, the argument of counsel, and the indictment, the court finds these vital constitutional protections do not reach the actions and statements alleged by the state, nor do the statutes themselves facially violate the First Amendment. The defendant's motions are therefore denied. So bottom line, the statutes are not facially invalid. They're not invalid on their face, to be a little redundant, and the allegations in the indictment are sufficient to at least cast some doubt on whether or not the speech at issue is purely political First Amendment protected speech or speech in furtherance of felonious crimes as alleged, which is not protected First Amendment speech, because the judge makes clear that First Amendment protected speech does have certain limits, and we all know these limits: defamation, threats, etc., etc. And if the speech at issue was said in the purpose of furthering a crime, then it would not be protected First Amendment speech, and we can't come to that determination right now. So off to trial you all go. Then we go into the First Amendment considerations on page 2. These excluded categories include speech integral to criminal conduct, fraud, or speech presenting an imminent threat that the government can prevent. Restrictions on, quote, speech integral to criminal conduct have never been thought to raise any constitutional problem, end quote. So after having laid out that exception to First Amendment protections, the judge goes on to consider the as applied and comes to the following conclusions. As applied constitutional challenges typically rely on the development of a factual record after trial. Yet our Supreme Court's decision in Hall, Boyer, and Major demonstrate that as applied challenges may be considered pre-trial using the limited record at hand. What does this mean here? That typically you raise the as applied unconstitutionality after evidence has been adduced, that the manner in which the law is being applied at the case at issue is unconstitutional. It's after evidence has been presented. Right now we're at sort of pre-evidentiary, a pre-trial motion to dismiss it, and the judge says, look, typically it's after evidence has been adduced where you go for a directed verdict, and I made that commentary during the hearing where the judge said, isn't this something more for a directed verdict? And I said, look, he's giving his hand away right now, that's what he's going to do. So there are cases where you can make this pre-trial motion to dismiss, and lo and behold, it's not going to be one of those exceptions to be granted at this point. After interpreting the indictment's language liberally in favor of the state as required at this pretrial stage, the court finds that the defendant's expressions and speech are alleged to have been made in furtherance of criminal activity and constitute false statements knowingly and willfully made in matters within a government's agency's jurisdiction which threaten to deceive and harm the government. The judge goes on to clarify a little bit later that it's not merely by virtue of the fact that a statement is false that it becomes actionable, but in this case, they've alleged that the statement was false and made in furtherance of a felony crime. Look, all you have to do is make specific allegations and you'll never get it dismissed at a pretrial stage until evidence is adduced, and the judge says this a little later on. Nor is a false statement knowingly and willfully made in a matter within a government agency's jurisdiction and which threatens to deceive and harm the government free from restrictions. Now, important to appreciate, the judge is not saying anything is true at this point in time. All of the judge is saying is that the state has alleged these allegations. The state has made the claim, made the allegations that the defendants made knowingly and willfully false statements in furtherance of the crime of trying to overturn the 2020 election. So by virtue of the fact that they've made sufficient allegations to survive this motion at this stage, it's going to survive this motion to dismiss at this stage. In addition, this court sees no reason to depart from the Georgia Supreme Court's ruling in Haley, which denied a similar challenge to OCGA Section 161020. The statute does not blanketly apply to all instances of false, fictitious, or fraudulent speech, but rather is limited only to such, quote, knowingly and willfully false statements that are made knowingly and willfully in a matter within a government agency's jurisdiction, end quote. Accordingly, quote, the state may lawfully punish such a course of potentially deceptive and injurious conduct. Precedent is to the effect that this statute was not overly broad and facially unconstitutional, facially invalid, so they're going to respect that precedent. On the allegations of the indictment, the state has made sufficient allegations that the false, knowingly, willfully false statements were made for the purposes of furthering a crime, therefore not protected under First Amendment protections. So we're going to go to trial, and they're going to raise all of this more substantively after evidence is adduced or after no evidence is adduced. That is to say, no evidence of willfully false, knowingly false statements made to overturn an election. Because it might just come out after a hearing that all of the statements at issue were in fact correct. Who knows? We'll see what comes out after evidence. But as relates to the motions at hand, the judge concludes with the following and thus ends his judgment. Page 13, further, the statutes do not facially violate the defendant's freedom of association. Our Supreme Court has upheld legislation impacting the right of association after, quote, balancing governmental interests in protecting the integrity of the democratic process and to ensure fair elections against an individual's fundamental rights. Conclusion, without foreclosing the ability to raise similar as-applied challenges at the appropriate time after the establishment of a factual record, the defendant's motion based on First Amendment grounds are denied. So ordered this 4th day of April, 2024. So as I predicted, and I'm really not taking too much credit for this prediction because it was painfully obvious that this was going to be the case, the judge says, look, after evidence is adduced, feel free to make this motion again if the prosecution fails to make any evidence proving that these knowingly false statements, proving that these statements were false. If they were false, that they were knowingly false, and if they were knowingly false, that they were made in furtherance of a crime. If the prosecution fails to make any evidence to that effect, at that time, re-present a motion, and I'll think about it a second time. But for now, it's premature. Let's move on with the trial. After we see what happens with the Georgia Court of Appeal, because they have filed their motion for permission to appeal to the Georgia Court of Appeal. We will see if a judge on the panel says, yes, we're going to take it up. We're going to see if the judges disqualifies Fannie from the file, which would throw a monumental, a nuclear wrench in the wheels of this persecution, because I nonetheless still feel that this is a wicked persecution. We'll see what happens, but if you like what I do, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Viva Frei on Rumble, the Viva Frei on Twitter, vivabarneslaw.locals.com for the best community anywhere on the interwebs. More important than anything, get out there, exercise, go fishing, get some sunlight, be healthy, and now you know you vlog. Peace out, peeps.